Good evening, friends. I hope my earlier discussion on various social issues have benefit to some extent, if not to all of you, to some persons. So आज का भी मैं टॉपिक है वो आपको लोकल लैंग्वेज में डिस्कस करूंगा बिकॉज इट इज फॉर द सोशल बेनिफिट ओनली. तो इसमें मैं हिंदी और थोड़ी सी इंग्लिश और पंजाबी के मतलब वर्ड्स यूज करूंगा. तो आई होप इट इज अंडरस्टैंडेबल टू ऑल ऑफ यू. तो सबसे पहले जैसे सबको पता है बायोलॉजिकली जेंडर सेक्स नॉट जेंडर सेक्स इज क्लासिफाइड इनटू मेल एंड फीमेल. Transgenders are people who despite having a particular biological sex either male or female recognize themselves from different to that male and female. Some male recognize themselves as female, some female recognize themselves as male, and some recognized themselves not belonging to either of the sex. इसके अलावा बहुत कम परसेंटेज जो बर्थ के टाइम पे सेक्सुअल एबनॉर्मलिटीज के कारण होती हैं, दैट आल्सो फॉल्स अंडर द ट्रांससेक्सुअल कैटेगरीज, ट्रांसजेंडर कैटेगरीज. तो ये बात होगी जेंडर के टाइप पे. देन नेक्स्ट कम्स द सेक्सुअल ओरिएंटेशन. सेक्सुअल ओरिएंटेशन इज नॉट ऑलवेज टुवर्ड्स ऑपोजिट सेक्स. तो किसी लोगों को सेम सेक्स के टुवर्ड्स ओरिएंटेशन होती है, कोई क्यों दोनों ऑपोजिट एज वेल एज सेम सेक्स के टुवर्ड्स ओरिएंटेशन होती है. तो दिस इज ए साइकोलॉजिकल फिनोमिना. इसके अलावा दूसरी बात जो जेंडर आइडेंटिटी पे है, जरूरी नहीं है कि उसने अपनी ट्रांससेक्सुअल सेक्सुअल सर्जरी करवाई हो टू रिकॉग्नाइज हिमसेल्फ और हरसेल्फ एज ए ऑपोजिट और अदर जेंडर. करवाई भी हो सकती है, बट दिस इज नॉट ए कंडीशन टू रिकॉग्नाइज समवन एज ए थर्ड जेंडर, transgender, that he must have undergone some surgery. तो ये फर्स्ट क्वेश्चन उठा सुप्रीम कोर्ट में नालसा वर्सेस यूनियन ऑफ इंडिया. केस फाइल किया गया कि कॉन्स्टिट्यूशन प्रोवाइड करता है इक्वलिटी टू एवरीवन अंडर आर्टिकल 14. सुप्रीम कोर्ट ने बोला द वर्ड यूज इन आर्टिकल 14 इज पर्सन. सो पर्सन कैन नॉट बी लिमिटेड टू मेल और फीमेल बायोलॉजिकल सेक्स. इट कैन बी एनीवन in between the two, transgender also. Then article 15 और 16 में word use is citizen for the employment or other discrimination. Supreme Court also said citizen is also not confined to a two gender biological gender. It also includes any person, any gender. Then 19. This is the main article, clause A or subclause 1 of the article 19. Talks about the expression, freedom of expression. So gender identity is also expression, someone's expression to recognize himself or herself despite being a male or a female, male being a female and female being a male or any other type of gender. It is expression, how he is expressed. Supreme Court also noticed that sometimes there are, this also includes cross-dresser. Male likes to wear female dresses. It is a mode of expression. Female likes to wear male, have the haircuts like male. project herself as a male. So this is a more gender expression, gender identity, how one recognizes himself. Or sexual orientation is a emotional, psychological attraction towards the same sex or the another sex. This is a sexual orientation. These two difference होगी. सुप्रीम कोर्ट में इसमें बोला कि नालसा में इंडिया जो चैलेंज हुआ नालसा में वो हुआ कि देयर इज अ डिस्क्रिमिनेशन एंड इसमें जो है ट्रांसजेंडर थर्ड जेंडर्स को स्पेसिफिक राइट्स और बैकवर्ड क्लास कंसिडर करके उन्हें स्पेसिफिक राइट्स दिए जाए. सुप्रीम कोर्ट ने बोला यू आर इक्वल. हाँ, बट सुप्रीम कोर्ट ने रिकॉग्नाइज किया sometimes they are not given access to the public services, public utility services and public essential services like in the employment, education, use of toilet. They are being discriminated. Supreme Court also observed that various government institutions, even the government itself, identify people on the basis of biological sexes, that is male and female. So Supreme Court issues certain direction कि the biological, the third gender should also be considered. They need to be given equal right. So this is the thing in the NALSA. Supreme Court in this case commented that 3677 is not the subject matter that has already been held in the Suresh Kaushal versus Nas Foundation case, so it does not touch it. But subsequently, the Navtej Singh Johar versus Union of India, Supreme Court recognized that 377 is violation to the gender identity, sexual orientation. Supreme Court recognized the definition of sexual orientation and gender identity given in the NALSA. Supreme Court in Navtej Singh Johar said if anything done in the private due to the sexual orientation, that is not an offense. Supreme Court also recognized that during the pre-independence time or even post-independence earlier, transgender has been considered as against the social norm. They have been prosecuted despite having the any illegal activities whether done by them or not, only on the ground of their sexual orientation. Under section 377 they are booked. So Supreme Court struck it down. Supreme Court also recognized that there has been amendment in section 375 definition of rape. Very wide definition of rape has been given, which the definition also includes not only the forceful vaginal sex but also the forceful anal sex. Government of India said that this section is there to check the abuse of the children and women with respect to the forceful anal sex or the non-natural sex, unnatural sex. Then Supreme Court has said the 375 has been amended, and in regard to children, Supreme Court said POXO Act has been enacted. So this apprehension is not there at this time. Supreme Court recognized the society has changed. So constitution needs to be interpreted with the changed circumstances. Constitution is a living document. So Supreme Court said yes, 377 is violative of right to equality, right to privacy, right to expression, and stuck it down. Qua, but only limited the Supreme Court struck it down only limited to the extent of consensual sex. Note for the bestiality, if the bestiality means if the sex is done with any animal. So in that case, the it is unnatural sex and is applicable because the section 375 and POSCO 375 pertains to the forceful sex against the consent with the woman, and POXO involves with the children. So accept these categories and accept in the consensual sexual unnatural sex, consensual anal sex. This section is applicable to if unnatural sex is done with any other animal or anyone else except these women and children. This section has been quashed. Supreme Court categorically said consensual anal sex 377 is not applicable. सो मेरा ये आज का मोटिव आपको क्या था, मैंने ये 377 जब क्रैश हुआ उसके बाद मैंने न्यूज पढ़ी थी which was an interview by the SP of Panchkula that अब 498 ए के साथ साथ 376 या 377 भी ऐड हो रही है. My only social awareness motive in this lecture is that Supreme Court has recognized the sexual orientation of the individual, and Supreme Court has also recognized that even if it is anal sex but consensual, then it is neither it is 375 nor it comes and falls under the 377. तो जैसा कि मैंने कल को भी मतलब पर्टिकुलरली दिया था, मतलब डिस्कशन की थी, तो उसके रिगार्डिंग अब लेटेस्ट में कल अब जजमेंट बतानी भूल गया कि केरला हाईकोर्ट की जजमेंट है, अगर मैरिड वुमन एक्स्ट्रा मैरिटल अफेयर में जाती है तो बाद में क्लेम करती है कि देयर वाज ए प्रॉमिस ऑफ मैरिज. केरला हाईकोर्ट हैज सेड दो हाउ कुड ए प्रॉमिस ऑफ मैरिज विद ए मैरिड वुमन. So the 376 is not made up. Similarly, Supreme Court, looking into the present circumstances, has protected the transgenders, and not only transgenders but the heterosexual or homosexual individuals as well. Article 377 has been struck down. Oh, this was my only short lecture. If you have any doubt regarding any of the things, you can just drop me comment. I will try to reach out you. So thank you very much. Good night.